Hello to everyone out there, and thank you so much to join us here on Immigration Talk Show. I'm Nipasa, and I'm going to be your host for this session that's lined up. And before we have our guest join us, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. I hope you keep that in mind, friends. And please do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And feel free to share this content with your friends and family out there who will most benefit with what's lined up for you, because today we are going to have a very important discussion on, are you at risk of H-1B trouble, and we're going to discuss different triggers, legal pitfalls, and how probably you can protect yourself even from all of these things that could put you into trouble or your H-1B visa into trouble. So to help us dive deeper into this topic and answer to all of your questions that you have regarding H-1B, we are going to be joined by none other than attorney Chand Parvathaneni from SPB Law Firm, Dallas, Texas. So please help me welcome him. Hi, Chand. How are you
Hello,
doing
Nipasa.
today?
Pretty good, Nipasa. Thank you so much for this session today, and hopefully we'll have a very productive session discussing about various H-1B compliance issues.
We are. And it's always a good session with you because you take each of the questions and you answer them so patiently. So I'm sure that folks out there are going to have a treat today with you here with us. So I think we should just dive right into the question if that's fine. Or do you want to say anything before we start off?
Sure. So, I mean, in the last month, in April, we saw a lot of service terminations. So we saw what could happen if people don't comply with the regulations. So, from that past experience, the goal is how are you prepared to make sure your H-1B is always safe? And the answer for that is always comply with the rules and regulations, and it is very easy. So there are a few things that you always make sure when you're on H-1B, and that is you have an LCA. Always make sure you have access to your LCA, and you get paid as per the LCA terms. You work as per the terms of the LCA, and just continue to do your role, and don't get into any trouble with the law, any kind of trouble. And what that means is no public intoxication, no reckless driving, something what people might consider a minor infraction. Infraction is an infraction. So it's kind of a good time to kind of see what exactly it takes to make sure your H-1B is secure. And it's very easy. Sometimes you just have to kind of brush up the law, kind of be educated, and know what you're required to look at. And doing so, you know what to do, what not to do. And that's the idea of this session today. Some of the things that where DOL can come and check, or USCIS can come and check. What if somebody does not follow the rules? What will happen if the employer does not follow the rules? What happens if the employer does not follow the rules? What could happen? So a good time to kind of regroup and see what the regulations are, and see how best to kind of ensure you're in compliance with all the rules and regulations.
Absolutely. It's very important to know the laws and follow them, each one of them. So thank you so much, Chand. And I'm looking forward for this whole session today because I have so many questions lined up for you, and I'm sure folks will join us with their questions as well. So, yes, and another thing, friends, we are streaming live right now on YouTube, but you can also check us out on LinkedIn, Facebook, X, and on Instagram and connect with us. Hit that bell icon so that whenever we have discussions like these, you're notified. So, yes, the first question is already on the screen, Chand, and I wanted to ask you, what are some of the red flags, that USCIS looks for when reviewing the H-1B petitions, especially for third-party placements? So, first off, what is a third-party placement?
Sure. So, so in the H-1B world, we have two kinds of positions. One is a third-party placement, and a third-party placement typically means the H-1B worker. The worker is assigned to a client site, so he is not working in the company. Like suppose you have a full-time employee of Microsoft, so that employee will work at the location of Microsoft Office. That's an in-house position. So in contrast to that, the other side is you have employers who have employees, but they're assigned to work at a different location, at a client location, not the company's location, not the employer's location. So all a third-party placement means is you have an employer, but you're not working for the employer at the site of the employer. You're actually working at a client location, at a third party client location. So that's what a third party placement means. And in the H-1B world, when we have a third party placement, USCIS has a whole different way of looking at things, because the employee is not working directly at the location of the employer. So what that means is USCIS wants to make sure a couple of things are done right. Employer-employee relationship is followed, and the employee is doing proper specialty occupation job. So there are a couple of things. There are a couple of red flags that normally are always checked by USCIS when it comes to third-party placement. And recently, what happened is in the month of January, this January, uh, there were change in some rules, and pursuant to those changes, even the I-129, the H-1B petition that gets filed, USCIS made some changes. So now upfront they're asking whether this particular gig is a third party placement or not. So what that means is USCIS can easily look at the current H-1B filing, look at the form, and easily understand what's a third party placement and what's not a third party placement. And when it's a third party placement, always USCIS is looking for a couple of red flags. And the first and the foremost thing is employer-employee relationship. So one of the things that USCIS requires is that the H-1B employer, the petitioner, who will be the employer, will maintain the right to control over the employee's work. So that is very important. And how do you show right to control? So things like, are you paying your employee? Are you paying taxes? Are you supervising your employee? Are you providing your employee who's working at a third party location? Is that person getting the right tools and instrumentalities to do his job? Yes or no? So that's one of the things that USCIS is definitely looking for. And what that basically means is they're looking at, are you paying the employee properly? Are you reviewing the performance of the employee? Do you have a proper reporting structure? What if the employee has some issues? How does he report back to you, because you are the employer, even though your employee is working at a third party location? So this is one of those things that is very critical, always looked for when it's a third party placement. Because the idea is that if somebody is working in-house, your employer, so the employer is constantly communicating, because the employee is sitting in the office or directly working under the employer, the petitioner. But when it comes to third party, it is understood that the employee is at a third party client location. On a day-to-day basis, the employer might not be able to see what the employee is doing. So because of this reason, the right to control becomes a very critical part for a third party placement. Next thing they're looking for is inconsistent contracts or incomplete contracts or contracts having some issues. What that means is when we say third party placement, you have an employer who is the petitioner, but the employee is working at a third party location, and it's always pursuant to some contract, either through some SOW, statement of work, or either through some purchase order, or either through some other contract. And what USCIS is looking for is the contract will probably say something, things such as you have to provide services from this location, you have to provide services in this occupation, maybe as a software developer, maybe as a software tester, or something of that sort. So USCIS is looking for some gaps or contradictions in these contracts. And what that means is if the contract is saying the employee is supposed to work from certain location, is your LCA also consistent with that? Because if your LCA says the employee is working from, say, Texas, the contract, the purchase order, or the statement of work says that the employee has to work from, say, New Jersey. So there is a contradiction. So these kind of gaps or contradictions in the contracts, what you're supposed to do, what kind of services you're supposed to provide as per this contract versus what you have in your petition. If there is any gap, that's a red flag. USCIS is going to check upon that. So the bottom line is the employer, when they are filing the petitions, you always have to make sure you are in compliance. So whatever the contract asks, if that is what is being done as a part of this H-1B petition, you have to make sure your filing and the contracts are in sync. So that is also a very important thing. Next thing is specialty occupation. Any doubts regarding that? So the red flags that USCIS is looking for are things like, what exactly is your contract requesting? So the services that your contract requests. So if the services are too generic, something like business analysis, for example, something too generic where you don't really see a need for a specialized worker, a specialized degree, USCIS is looking for those kind of red flags. So what they're looking for is the job duties that you have, the job duties that you require under the terms of this petition, the job duties that the client requires. Are they specialized enough? Are they generic enough? So these are the kind of things that they are definitely looking for. And next thing they're looking for is, do you really have definitive work or do you have lack of work? USCIS does not allow non-speculative work. So when you have a third-party placement, do you really have non-speculative work? And what that means is, do you really have work on the day of filing? Do you just have a MSA, a contract, or do you really have a specific purchase order or a specific statement of work where you can clearly show the work is non-speculative? And what that means is, you're filing on the day of filing, you know that work is required. So there is a difference between speculative work assignment and definitive work assignment. USCIS requires non-speculative work, and that is very important. And that is one of the things that USCIS wants to make sure if it is a third-party placement, because tomorrow, what if there is no work at the third party? So these are the kind of things that are very relevant, very important, and that's a red flag if the work looks speculative. So that's another thing that USCIS is looking at. And other uncommon things such as the petitioner's size, the size of the company. The company is very small. The company does not have enough revenue. They want to make sure the company has resources to pay. So that's another thing that's a red flag. So when you have a third party placement, the company is a very, very, very small company, or the company has just started, it could be a red flag. It doesn't mean that the company is fraudulent, because a company can be new, a company can be very small, and the company is still allowed to sponsor H-1B workers. But if your company does not have the right resources to pay the wages, that could be a red flag. So when you have a company that is very small, but they're filing for multiple H-1B workers, that's a red flag. It is not something that it is not permitted, but it is definitely a red flag. So USCIS really wants to make sure the company has the resources to pay wages. There is enough oversight with the employees and so on. So that's a red flag, but again, it is definitely allowed. Another thing that we commonly see with third-party placements is wage level, because when you have an employee being placed at a third-party a client location, and if it is a wage level 1 kind of a case, wage level 1 means it's an entry level. An entry level means typically these people are handheld. What that means is they're really supervised. They get enough supervision, enough uh, mentorship, because it's an entry level position. When you say it's a wage level 1 position, so USCIS really wants to make sure when your employee is placed at a third party, if somebody is entry level, how are they even doing their job? Because they need a little bit of supervision, because it's an entry level position. So when you have a client location, employee being placed at the client location, entry level, wage level 1 positions always have extra scrutiny. It is not that they're not permitted, but again, it's a red flag. So USCIS wants to really make sure, even without proper day-to-day supervision, employee can do the job, especially when it's a level 1 job. So it's a red flag. Definitely USCIS will scrutinize that part. So these are the kind of things that always the employer and the employee always have to make sure, because these are red flags. That doesn't mean that it is not permitted. Just a red flag means more scrutiny. Again, if it is a valid assignment, third-party client assignments are completely valid, and most of the cases that we deal with are always third-party client assignments.
All right, Chand, that was very detailed, and thank you so much for taking that up. And I think it connects to also Lingaya Rao's question, which I would like to quickly take it. And if you've already answered
Sure.
as you explained just now, you can just give us a small summary for contractors. Client will not support giving letters of verification at FDNS visit filing H-1B. Is it okay if employer providers his document? Sorry, if employer provides his documentation with client letters.
Sure. You're totally right. A lot of clients will not issue client letters, and that happens all the time. The requirement is the company has the burden of proof to prove that you have a bona fide assignment. Client letter is not a mandatory document right now. It is not mandatory. It is good to have, but it does not mean that it is end of the case if you don't have a client letter. All that is needed to be proven is you have a bona fide assignment. And what that means is sometimes you can show your work product. So work product. So you have a client FDNS site visit, and you're getting paid, and you're performing work, and you have emails to prove it. You have like an ID card from the client to prove that you're working at the client location. Or sometimes your end client will have a portal, and the client's portal will show that you're working as a contractor at that location. So there are various ways you can prove that your assignment is still a non-speculative work assignment. You're actually working in that assignment. Things like your ID card at the client location, maybe some of the emails, if you can share emails to show you're doing work. Maybe your intranet portal from the client location showing the active profile, showing an active email at the client location. So there are various things that you can use to prove that you're having a bona fide assignment. Employer can definitely provide their documentation, because the rule is you have to prove by preponderance of evidence. The burden of proof is preponderance of evidence, and what that means is you have to prove that more likely than not, at least 50% of a chance, more than 50% of a chance that whatever you're saying is valid. So what that means is, yes, your client might not uh, give a letter, but you might have other evidences, a lot of other evidences, like your work emails, work product, your timesheets, your ID cards, your vendor invoices. So there are so many things that your employer can use to prove, even if the client does not support you when there is a FDNS site visit. Because all USCIS is trying to make sure is, yes, you have a valid assignment, you have a genuine and a bona fide assignment. That is what they're trying to prove. And even if the client does not participate, you should still be able to prove through various other evidences and prove that it is a genuine assignment, not a speculative assignment. Because USCIS wants to make sure you're not benched. Benching is illegal, and that is what is the goal. So if you can prove through other means that you're not benched, you're being paid, you're working as required, you're in the same metro area that your LCA requires you to stay, and doing your job, you will be okay. You will get through even if the client does not give a client letter.
Okay. Well, thank you so much for taking that up for Rao. And thank you, Rao, for joining us. We also have Rag and Sid. So I'll say hi to Rag. He says, hello, Nipasa and Chand. And he's asking, any trending H-1B or H-4 port of entry issues?
Again, I mean, what we're seeing is, yes, we're seeing scrutiny, but if you ask me, like, how many number of people are getting sent back, whatever I saw last year, the year before that, in terms of percentage, it is still the same. So I've not seen like an increased number of people being sent back. We definitely have heard cases, even recently, of people being sent back. But again, in terms of volume, in terms of percentage, whatever we saw last year under Biden's administration, the year before that, it's the same trend. However, what has changed is there is a little bit more scrutiny, and what that means is you probably can expect more questions. And end of the day, you have an H-1B approval, you have a visa, and what that means is USCIS has gone through the vetting, the consulate has gone through the vetting to give you the visa. So in general, majority of the people never have an issue. But what happens is there are always some cases that always will trigger a secondary inspection. And majority of the cases that I see, even if you go through a secondary inspection, yes, you might have a 1-2 hour delay, but majority of the time, because most of the people are doing things right, they don't have a problem. Very few cases will always have an issue, and that is when what happens is they get sent back from port of entry. But in terms of are we seeing a jump, very, very high number of such cases? Definitely no. Occasionally we keep hearing of such cases. Even recently we have heard of such cases. And almost always when I see somebody being sent back, what typically happens is they give some kind of they kind of give some answers where the CBP officer will prove that there is some kind of misrepresentation. Maybe they have taken their phone, maybe they found something incriminating on their phone, things like maybe a fake resume or maybe something incriminating, and the officer was able to prove that they're lying. Because if somebody misrepresents or gives a false answer to a CBP officer, that is when people will have an issue. So in terms of the volume, I don't think that there is any uptick or huge number of such cases. Whatever normally happens is what is happening. And the idea is that if you get called for a secondary inspection, always make sure there is no misrepresentation. And whatever the officer asks, try to answer, try to cooperate with them. And majority of the cases should not have an issue.
Thank you so much, Chand. And yes, I think it's most important to be cooperative. So whatever questions they ask, answer what is required. So
And I
that,
want to add one thing on top of it. So
sure.
I've got a lot of calls lately about H4 EAD folks, and the
Mhm.
question being raised was, hey, we saw this social media post where they said you have a multiple job, like somebody on H4 EAD had multiple jobs. Is that illegal? Are they going to get sent back because they have it? That is not true. So just because you have multiple jobs on H4 EAD, because H4 EAD is a work authorization, you are allowed to do any kind of a legal job, any job that is legal under the law, you can do it. So if you have multiple jobs, job one, job number two, you're legally working, you're legally paying your taxes. That is not wrong. So just because there was a social media post, there is more to the social media post, something that probably was not disclosed. So multiple jobs under H4 EAD are allowed. And one thing to add is even on H1B, somebody can have a multiple job. And the way you do it is there is something called concurrent H1B. So if things are done the right way, the company is filing a concurrent H1B. Company is letting USCIS know that it's a concurrent H1B. Even on H1B, you can still do a multiple job. So if things are done the right way, multiple jobs are not an issue, because we had a lot of questions about are people with multiple jobs having issues at port of entry. If it is done the right way, if you're an H1B, make sure you file a concurrent H1B. If you're an EAD, you are an EAD, which means you can do multiple jobs. So if it is done right, I don't think you should see any issues at port of entry for multiple jobs.
Well, thank you so much, Chand. I think that will be very helpful for most of our viewers. So that was good. And Rag is also having another question, but Rag, I'll just ask you to stay with us because we'll just follow with a couple more other questions first. And my question to you, Chand, is how does USCIS evaluate, whether an H-1B position qualifies as a specialty occupation in today's changing work landscape?
Sure. So the main requirement for H1B is it has to be a specialized job. So if it is just like a regular job, like say you want to hire office assistant, for example, an office assistant is a generic job. So what that means is you don't need a specialized degree in a particular field. So every job, so USCIS will evaluate and see if it is a specialized job. And their definition of a specialized job is very simple. They want to make sure that a job requires a bachelor's degree, at least a bachelor's degree, or something higher. Maybe, if the job requires a master's degree, that is still okay. The minimum requirement should be a bachelor's degree. And on top of it, the degree has to be in a specific specialty. So to do the job, as long as you require a bachelor's degree or a higher degree in a specific and a specialized field, that job will qualify as a H1B. So what that means from a practical perspective in the current landscape is USCIS will evaluate every job, which means they're looking at the job duties. They're looking at the ONET code, and they are seeing, does this job require a specialized degree in a particular field? If the answer is yes, that job will qualify for H1B and USCIS will not have a problem. But if the answer is, hey, for example, this job, this is a job where you don't require a bachelor's degree in a specific field. For example, an office assistant, you can probably have a requirement in a generic field, or sometimes a lot of office assistants might not even require a specialized bachelor's degree, a degree in like computer science or engineering or something of that sort. So those are the kind of jobs where USCIS will come back and say, no, based on the normal industry standards, this job cannot be qualified for H1B. So that's the overview. And the way USCIS does is they have four criteria. If you meet any of the one criteria, they will agree that it is a bachelor's requirement kind of a job. So what they're looking for is, the first thing is industry norms. So according to the industry norm, if the degree requirement is common, then they'll agree that it is a specialized job. So as an example, software developer. So for software developer, as an industry norm in general, it is widely accepted, very commonly accepted, that to do a job as a software developer, the industry does require somebody to have a degree in computer science, IT, or a relevant field. So that is one prong that USCIS will use. The other prong, they look at employer's practice, the prior practices. So if the employer always hires somebody with a bachelor's degree or a higher degree for that particular position, that's also can be used. That's another way of proving that it is a job that requires a specialty occupation requirement. So that's one way. The other the other requirement is the normal requirement. So what that means is USCIS is looking at the occupational outlook handbook, the ONET requirements, and so on. And if those show that this particular job normally requires a bachelor's degree, they will also allow that. And the fourth way is the duties. So the duties are very specialized, very complex. They analyze it. And then you're able to prove that the knowledge required to do this job does require a bachelor's degree. That's another way. So there are various ways you can prove the job is specialized. And USCIS typically has four prongs. Any of the four requirements, if they are met, they'll agree that it is a specialized job. And from an H1B perspective, what you should avoid is, if your company has a job that is very broad, very, very broad, such as generic business analyst, a general manager, one of these job positions, USCIS could come back and argue that it is too broad or it is too interdisciplinary. What that means is, yes, you require a bachelor's degree, but it is too broad of a degree. it is probably not a specialized degree. So USCIS typically comes back and argues whether general business or general liberal arts, those kind of degrees are specialized. So if a job requires one of those degrees, the H-1B always becomes tough because you're not able to challenge the specialty occupation requirement. So in general, what you should do is the best practice is always show the detailed job duties, always show the technical depth, and show the technology or the technical reasoning on why you require a specialized degree. For example, if your job requires data modeling, a lot of application programming interfaces, APIs, a lot of coding frameworks, it is very clearly shown that yes, a degree in computer science IT is relevant because these technologies are so highly specialized. So the bottom line, avoid any generic or vague job descriptions. Be very, very detailed and be very technical. And doing so, you'll be able to prove that it is a specialized job.
And very important that is. Thank you so much, Chand, for that detailed explanation. Now we'll quickly take up a few more comments. Sid says, "Hi Nipasa and Attorney Chand." Hi Sid, thank you so much for joining us here on YouTube. And Sid is asking, "Hello, if I change my residential address through my USCIS account, is that enough or do I still need to fill an AR11 form? The USCIS account doesn't show an address under my profile settings. And how can the filed AR11 PDF form for change of address be submitted online?"
Sure. So you can go to the AR11 form. It's available on my USCIS website. So the rule for AR11 is anytime you move addresses, say today you move to a new address, within 10 days, you have to make sure AR11 is filled. And AR11 can be filled in two ways. If you go to the USCIS website, it has a paper format. So basically, it's a PDF. You can download the PDF, you can fill it up. On the bottom of AR11 form, it has an address. So you can simply FedEx it to USCIS. You can keep tracking of that AR11 form that is FedExed over to USCIS. That is one way of doing things. The other easier way is you can just do it online. So you go to the AR11 link, you click on that link, it will take you to my USCIS website, and then you'll be able to fill up AR11. So it's not just changing it in your profile, you actually have to file AR11, and it is very easy. You can do it online. Just Google the link. The link will take you to a USCIS website, and you can do it online and fill up that AR11. Just in case you're finding a little bit of a trouble doing it online way, do the paper way. Okay, the paper way, again, the PDF version is available on the USCIS website. Download the PDF and do it. But I always suggest do it the online way because online way is so easier. It is cheaper. You can just get it done. Save a screenshot. Just keep it with you. You're done. Okay, but in case you have a challenge doing it through the online account, always use the paper copy. That being said, always file AR11. It is very easy, and it's always a good way of making sure you are compliant with the rules. The requirement for AR11 is it is not just H-1B folks. It is anybody that is not a US citizen. Anybody that is not a US citizen, including green card holders, they have to do AR11. So it's a good practice. Just Google AR11. The first link will be a USCIS link. Go to that link and you'll be able to finish it off.
Yes, all the best, Sid. Get it done. So, also, friends, I would like to say please subscribe to our channel. Our handle is at Immigration Talk Show, especially folks out there whose questions just got answered. If you haven't as yet subscribed, subscribe now, and also hit that bell icon so that whenever we have discussions like these, you're notified. Also, check us out not just here on YouTube, but we're also on LinkedIn, Facebook, X, and on Instagram. So connect with us and stay in touch with us. And also, friends, you can contact Attorney Chand Parvathaneni. And to do so, you can go to the link which is going to be here on the screen below. So go check it out, and you can contact Attorney Chand Parvathaneni even for one-on-one consultations. So yeah, moving on. Let's take up Satish and Ricky's comments. Hi, both of you. Thank you so much for joining us here on YouTube. Satish is asking, "I lost job and moved to H4 from H1B and applied for H4 EAD 4 months back. I am in a dilemma. Should I wait for EAD or move back to H1B? What are the chances of getting RFE after moving back to H1B?"
Sure. Uh, so again, if the H4 was filed timely, and when I say timely, what that means is you filed it before your 60-day grace period was up. Normally, in terms of your status, you should not have any problem. And when you want to convert back to H1B, so you have a pending H4 and you try to convert back to H1B. Normally, what happens is sometimes we see RFEs and they say, wait until the H4 is approved. It's a challenge. And again, until your H1B gets approved, you cannot work on a receipt. So normally, when you're doing a H1B to H1B transfer, you get a receipt copy, you start working on it. But when you are on pending H4, it is more than 60 days. Your company can file a H4 to H1B transfer. They can do it. The only rule, not normally, it is not a challenge, but the only problem is now you cannot work with a receipt. You have to wait until the case gets approved. So there is a little bit of time lag. So that is a challenge. So the main challenge is until the H1B is approved, you cannot work. And most of the time, it should not be a problem. That being said, you said that you have an H4 EAD. So if you have a job offer, one of the things that you can do is if you have a job offer, you can reach out to USCIS. And because you have a job offer and without the work authorization, you cannot start the job, which means that you are going to have financial loss. And if you have a financial loss, that is one of the reasons why you can expedite your EAD. So if you have a job offer at a certain point of time, and because your H1B is not approved, or because you're not able to work, what I would suggest is you reach out to USCIS. There is a process. If you Google expedite 765, you should see a link for USCIS. So there is a process to expedite your H4 EAD if you have a job offer. So what I would suggest is if you have a job offer, try expediting your EAD because you have a job offer, and you'll have financial loss if you can't start the job. And USCIS might be able to expedite your EAD, H4 EAD, which in that case would be a lot faster than going through the H1B process, waiting for the approval to happen. Okay. So what I would suggest is, worst case, yes, you can come back to H1B from H4. But because in the interest of time, if you want to do it faster, definitely try to expedite your H4 EAD. Go through the process of expedite and hope that USCIS approves your H4 EAD under the expedite process.
Yes, and all the best, Satish. I hope you get it done. And let's go on, Chan. Thank you so much for taking that up. Don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. So now let's go on to Ricky. Ricky is asking, hello, for the first time, H-1B visa stamping, I have heard it's suggested to get stamping done from the home country, which is India in my case. Do you suggest the same, or can I get it done from Europe? For H-1B workers, how can one print? Okay, let's take one at a time.
Yeah. So sure. So uh, so when it comes to the first time H1B stamping, some countries still allow third country nationals, TCNs. And
Okay.
for example, Mexico typically does not allow third country nationals. Canada typically allows third country nationals. Some countries in Europe allow third country nationals. Problem is the consulate rules are localized and they keep changing time to time. So what that means is, if you go to Europe, sometimes they will allow third country nationals, and sometimes they will say they'll refuse, and they will say you have to go back to your home country. So for that reason, the best practice is just to go to the home country, because there is always a low risk that there is any problem, because the country, at least the consulates, will not refuse you to come in for stamping. The problem with other countries like Europe or other countries is sometimes they're okay, and sometimes all of a sudden they'll change rules and say, no, you have to go back to your home country. And that being said, nowadays what we see is Canada is not causing a problem. Some European consulates are not causing a problem. Some consulates will say, because we are so busy, you just have to go back to your home country. So based on that, you have to take a decision. So I always say, yes, it is always good practice for your first time stamping to go to your home country. That being said, if you really have a need to stay in Europe for some time and you want to take advantage of that, go to the consulate, email the consulate or call the consulate and check with them, because you want to make sure that they're still allowing third country nationals, and these are localized rules. So if that particular consulate does let third country nationals come in for an interview, give it a shot. If you have a reason to be in Europe in that country for some time and you want to make use of that visit to also finish off your H1B visa. And normally, what I see is, if you're a resident of that country, say you're residing in London, for example, and or you're like working in London, maybe in some capacity, they are more than likely to allow you for stamping in that country. But if you're not at least working in that country or not a resident of that country, then sometimes it could be a challenge. Which is why most of you will advise you to just go back to your home country, because there are less surprises on whether you will be allowed or not allowed for visa stamping.
Thank you so much. Yes, so I think best to get it done from your home country, and all the best, Ricky. And let's take more questions. Yes, two more questions, I think. So for H-1B workers, how can one print I-94 to have it as a separate document from just being mentioned at the bottom of the I-797? And he's saying, thanks, my I-140 form is pending since last 7 months. Can I file premium processing for it at least for at this stage? And do you suggest it?
So for the I-140, I would definitely suggest you go to premium, and the reason for that is there is something called a 180-day rule, and the 180-day rule means from the day you get your I-140 approved, if you wait for 180 days and then say the I-140 gets revoked, the I-140 date stays with you. So the I-140 approval stays with you. So there is this something called this 180-day rule for I-140s. So the sooner you get your I-140 approved, your clock will start. Your 180-day clock will start. So from that perspective, I would always suggest that you try to get an I-140 approval as quickly as possible. And what that means is definitely, I think, try to get it done in premium, because some I-140 cases I'm seeing it take close to a year. So rather than wait, I would definitely encourage you to get it done in premium if your employer agrees with you, uh, because some employers probably might not let you do it because you still have to go through your employer. So if your employer agrees, I would definitely recommend you get it done in premium, because your 180-day clock starts from the day of your approval, not from the day of your I-140 filing. So from that perspective, always good to have an I-140 approval as quickly as possible. Not only that, it also helps you get H-4EAD for your spouse and so on. And now coming to the I-94. So I-94, the other way is you go to the CBP website, and on the CBP website you can download your I-94. However, the only thing is the CBP website will only have your I-94 from the last date of your entry. So the last time you entered the country, that is I-94 you can get from CBP website. But that I-94 you can always get it from the CBP website. And not only you can get it, it is highly important that everybody, when they travel back into US, the day they come into US or the next day, they should always download their I-94 from CBP website, always open it up, make sure it matches your I-797. If there's any mismatch, you will need to go to CBP and get it corrected, because a lot of times what we see is people forget to download their CBP I-94. Down the line, they realize that something is wrong in the CBP I-94, or sometimes they realize that the CBP I-94, the end date does not match your H-1B end date. And then you find by the time you realize that, you're probably out of status. So one important thing that everybody should do is you should download the CBP I-94, which is a separate I-94. Anytime you come into the country, go to CBP website and download this I-94. This is very important, and you always have to make sure you have a valid I-94 to stay in the country.
All right. Well, thank you so much for taking that up. And Ricky, I hope you got your answer. Please don't forget to subscribe to our channel if you haven't as yet. Our handle is at Immigration Talk Show. This goes out to all the viewers out there who are watching us right now. Whichever platform you're watching, go check us out on YouTube. Our handle is at Immigration Talk Show. Subscribe and ring that bell so that whenever we have discussions like these, you are notified. So also check us out, friends. We are not just on YouTube. We are on LinkedIn, Facebook, X, and on Instagram. So connect with us. So well, I we do have more questions on our Facebook, and Teja has just joined us. Hi, Teja. Thank you so much for joining us on YouTube. Let's take it up quickly, Chand, and then we'll move to our Facebook questions. Do we
Sure.
have such 180-day rule for H-1B, or we can change even after October 1st on the first day of the start?
Legally, you can even change on the very first day. So October 1st, if you have like a new employer file a petition for you, you can change. There is nothing that says you need two pay statements or three pay statements or two pay cycles or 180-day rule, because the idea is the government does not want any employer to kind of force you to work for them, and they want to give you that portability. So there are rules in place that give you that portability, the H-1B portability. So if you have another employer who has a genuine and a bona fide job offer and you are qualified, you are free to take it up. There is nothing that says you are stuck with that employer for a certain time period. In general, so the H-1B portability rules say that you are allowed to change employers as long as the petitions are all bona fide petitions with bona fide job offers. So theoretically, if you have a good offer in October from another company, there is nothing that says you cannot join. Only thing is, make sure the company is genuine, make sure the offer is bona fide. If so, the company can file a transfer for you.
And he's also asking, will it be a problem if we want to change to a new company immediately after October 1st?
Not really, as long as the petition, the initial petition that you got an approval, that's a bona fide petition, and then the new petition is also a bona fide petition. Because what happens is, people are highly qualified, and the companies are also competing for employees, because H-1B is a very specialized program. So if a company gives you a better job offer and you are seeing career growth in that company, there is nothing that says you are stuck with this company. So you're free to take up this new offer. And again, people always take up this new offer because they're finding maybe something better offer, better in terms of salary, or maybe better in terms of career growth, or they see something strong. So, and that is what even the government encourages. People are free. People get a better opportunity. They're free to take it up. Only thing is, do it through the legal process, which means do not join this new company until that company files a proper, legitimate, bona fide petition with USCIS. So follow the process. If you're doing everything by the book, you make sure the petition is filed. Only then change the employer. If it is being done that way, you're fine. The only rule is, before October 1st, say the initial employer, the cap petition, if it gets revoked by the employer, then you'll not be eligible to transfer. So there is this important rule, because this H-1B petition is valid from October 1st. So if the employer revokes the H-1B before October 1st, then your transfer will fail. But after October 1st, if the initial employer has not revoked the petition, you're free to transfer to a new employer, as long as the petition is genuine and bona fide.
Okay, okay. And he was asking, but I think he took it up. He's asking, can we change before October?
Before October 1st, if the petition gets revoked, then there'll be a problem, because then the cap exemption is not valid anymore. And then if USCIS gets the withdrawal from your employer before October 1st, the petition gets revoked, you'll not be able to transfer if that happens before October 1st.
Okay, thank you so much, Chand, for taking that up. And this is for Teja as well. Thank you for for joining us with your questions. And please don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Ricky also says, hello all, thanks for this session. Thank you, Ricky. We are so glad that you could join us. And do not forget to share this content with your friends and family also who could benefit, and ask them also to subscribe. So, Chand, we have more questions. So let's take them up quickly from our Facebook groups, and control, if you could please display them. All right, so this first question is from an anonymous participant asking, my friend is a US citizen and has a 204C for 10 years ago. She never bothered to dispute it. Now she is in love with another immigrant. Can she marry and file for him?
So if somebody is a US citizen in general, and the marriage is bona fide, they will be able to file for a green card. And the way they do it is, they file for an I-130. And if somebody is outside US, they simply go through the consular processing. If somebody is in US, go through the 485 process. But assuming the marriage is genuine and bona fide, somebody being a US citizen can sponsor. The only thing is, they do have the burden to show that they have the financial means to sponsor the spouse. So what that means is, they have to do an I-864, and they have to provide an affidavit of support. They really have to show that they do have the financial means to sponsor the spouse. So US citizen can sponsor for the spouse, assuming the marriage is genuine and bona fide. There's going to be a lot of scrutiny whether the marriage is genuine and bona fide. And in this case, looks like it is a genuine and a bona fide kind of a thing, because she's in love with him and she's going to get married to him. So once that is done, they can always, the I-130 is mandatory. And depending on where the spouse is, whether in US or whether outside US, they have to follow the proper process, and then submit the affidavit of support, the I-864, to make sure they have the financial means, and then go ahead.
Okay. Thank you, Chand, for taking that up. And yeah, all the best. That's all I can say to anonymous participant. Now, going on to this next one, what are the steps for getting approval notice? Change of status from F1 to E2, and principal applicant got notice, but family notice is still pending. Should the primary applicant discontinue F1 status or wait for the dependent notice as family word F2 dependents? Please guide. Much appreciated.
Sure. So looks like they're changing the category from F to E, investor category. So once they file a non-frivolous change of status application, in this case from F1 to E2, so I think looks like the primary, I think, looks like they got their notice. The dependent looks like they have not received their notices. So the only thing is make sure everybody has a receipt notice. Once they have a receipt notice, I think if the primary person wants to discontinue F1, they can do it. The only problem is tomorrow if the E2 does not get approved, they will be out of status. But if the E2 got, they got an approval for their E2 application, the petition, then they're good. They're good to stop F1. They don't have to continue F1 because they've already filed for change of status and it's a non-frivolous filing.
Okay. Thank you, Chance, for taking that up. Now let's go on to this next one, which is asking, hi, I'm on E2 right now, but I have lost so many contracts due to my business partner as clients don't like working with him. And I had to open up a new LLC with a new partner and moved all the contracts under that LLC. How can I transfer my E2 under new LLC? I don't want to continue with the existing LLC.
Sure. So in this case, they would have to file a new E2 petition once again, and they again have to go through the same burden of proof. They have to prove that the business meets the requirements and all those things. So basically, they file a brand new petition and again prove their E2 case with USCIS, get an approval, and then go through it.
Thank you, Chand, for taking that up. Now go on to our next question. Control if you, oh, there it is. It's another anonymous participant asking, my cousin has faced challenges with his visa situation. He wasn't selected for the H-1B visa during his 3 years on OPT and is currently pursuing a double master's degree. This year, he also wasn't selected for the H-1B. His double master's program will end in May 2026, that is the coming year. What options does he have to continue with CVIS? Would transitioning to a PhD be a good choice, or is rejoining a master's program a better alternative? Are there any other solutions others in similar situations have considered? I'm looking for practical advice, not negative comments. Okay.
Yeah. Yeah. So I think one thing is, I think definitely, I think we will see a second lottery. There's a good chance. And what that means is end of July, first week of August. I think if you take a close look, I think we will know. And the reason I think a second lottery might be possible this year is because USCI has released the total number of selections from this year's lottery just yesterday. So I saw the numbers come out. They said they selected about 120,000 selections from the H-1B lottery this year. And when we compare it to last year USCI selected about 135,000 selections. And even then they had a small H-1B lottery. So to me, it looks like based on the numbers, based on the stats, a second lottery is probably possible. And again, there is no guarantee, but again, July, August, that's one thing to look out for this person, because he has a US master's degree, which means definitely I think the chances are a little higher compared to non-masters. So we will see. So that is one option. The second thing is, one of the things that you mentioned is his master's program gets completed in 2026, next May, which means he still has another chance for H-1B because he's in status next March when the H-1B lottery is done. So again, he has another chance. So at least I think there is a little bit of hope that he might get a selection in the lottery. Also in the stats that we just saw, USCIS also confirmed that there was almost 27% decrease from last year's filings. So clearly the number of filings went down, and 27%, that is almost a quarter of the filings. So it's a huge decrease. So compared to last year, there is a lot less demand for H-1Bs this year, at least from the registration data. So the data that USCIS has just provided yesterday, they confirmed that it's a 27% decrease in the number of people wanting a H-1B, the H-1B registrations. So that's a clear decrease. So what that means is less demand more chances of selection. Okay, so that's another probably thing that you might be looking for as you go forwards. That being said, any other visa classes? To me, again, doing another master's does not make any sense at all, because USCIS when could always come back and always want to see the answers. Why you want to again keep continuing doing a third master's? But again, if you want to do a PhD, you do have to justify. You have to justify your career goals. You have to make sure it is in line with your career goals. Also justify that, and not only justify, you also have to ensure that you comply with all the rules and regulations of F1, which means you have to physically attend classes, you have to pay tuition, you have to make progress towards your degree. So if you're doing that, I would say a PhD is probably an option. Definitely, I think third master's doesn't make sense unless it is in your career path. But if not, to me, a PhD is probably in the career path, but not another master's. And in terms of other visa options, so I've seen some people, I mean, go out of the country, work for a company, and try to come back on L1. That's one option. Some people, if they have publications or if they have some good academic record, O visa is one option. Some people have been trying for O visa. O visa is not easy. You do need to have something different, which means like publications, like some judging some competitions, maybe some newspaper articles, something of that sort. If you have something of that sort, definitely O visa is a very good option. So you can think about O visa. And if not, some people are also looking at the H4 and H4 EAD option. So if you get married to somebody who's in US, who probably has your spouse is on H1, that's another option. So these are some of the options that I see are practical. If not, I think your best bet is wait for the second lottery results, and then you have one more chance next year.
Well, thank you so much, Chand. I'm sure that has making our anonymous participant pretty hopeful. So, thank you once again for taking it up, and I hope folks out there are enjoying the session. Please don't forget to hit the bell icon and subscribe to our channel. Our handle is at Immigration Talk Show, and please feel free to also contact Attorney Chand Parvathaneni, and the link is displayed on the screen below. And when you contact him, don't forget to tell him that you watched him here on Immigration Talk Show. So also we have more questions from Ricky. We'll take that up. Ricky is asking, can filing the I-140 premium processing increase the chances of an RFE?
I would not say it will increase the chances of an RFE, because it depends on the strength of your I-140. So again, I normally don't think the chances of RFE are increased in general. That being said, you have to evaluate the tax return of your company. So normally the way I do it is I take a look at the tax return of the company, because the I-140, the most and the foremost thing is ability to pay. That is the main thing that USCIS is looking for, ability to pay. So if I find the ability to pay for the company is very strong, I don't have any problem recommending premium processing. But if I see the ability to pay a little weak, because you can simply see the tax returns, you can simply see your paychecks to see how much you have been paid. If that is weak, we never suggest premium processing. The reason is, as you add time, what happens is the company is paying you. They're including all that evidence as proof of paying you. The company has a chance to better their profits, because maybe in 2025 they get better profits. So sometimes if I find the financials of the company weak, then definitely I would say that, hey, in case you get an RFE, tomorrow you will not be able to respond back with strong evidence because your financials are weak. In those cases, what we suggest is just wait, because you're still employed with the company. Every month the company pays you. That is adding up as evidence that the company is paying you, the company has ability to pay, and so on. So that is why it is something that unless you really look at the facts of the company, look at the financials of the company, you cannot say, because clearly there are some cases where you should not be upgrading your I-140 if the financials are weak, if the ability to pay is weak, because the more you wait, the company is able to add more evidence such as your company's performance, your pay statements, and so on. So that's a thing that probably you should have the company attorney take a look and give an opinion on the financials of the company. If the financials are weak, I would definitely not recommend you to upgrade this to premium. But if the financials are strong, depending on the nature of the company, if the financials are strong, definitely I would recommend you to go for premium processing for your I-140.
Well, thank you so much, everyone, for joining us here. And I think before we go, Chand, if you could really quickly just take up this case study I had. And yesterday's session with Chand has been superb. So many amazing questions, so many people join us. So I would say thank you so much to each one of you. So we have been discussing on are you at risk of H-1B trouble, and we have been discussing so many other chances and options. So this case study, Chand, before we go, is for Ajay. Ajay worked at a consulting company on an H-1B and was benched for 2 months without pay between projects. So his employer told him this is normal. What are his rights and options now?
Sure. So the first and foremost thing is benching is illegal. So benching is highly illegal, and I think all the FDNS site visits we hear about, the goal is to look out for benching, because that is the whole reason why we even see FDNS visits. Because when they do FDNS visits, more they find about benching, or when people are filing for H-1B extensions or H-1B transfers, when USCIS is finding discrepancies in the pay statements, it is this whole benching issue is what causes so many site visits and all this talk about fraud in H-1B. So what that means is benching is illegal, and if employer is uh, benching H-1B employees, uh, USCIS finds about it, DOL finds about it. The employer can have severe repercussions, and what that means is sometimes you get referred for criminal prosecution, sometimes you get hit with huge DOL penalties, and so on. So in terms of recourse, the first and the foremost thing is the employee should always talk to the company and let them know benching is illegal. Because initially, if you discuss with the company, and the company, you at least you try to give the company a chance to fix the problem, because benching is illegal and the company has to pay the employee. To me, that is the best way, because the employee should not even wait for 2 months. Immediately the employee is benched, talk to the employer and say benching is illegal, try to work it out. Because from an employer perspective, if an employee is done with the project, employer should notify USCIS, revoke the H-1B, and what that means is employee now has 60 days of grace period. So the employee is in good shape because they have 60 days grace period. They can take care of the status issue. Employer is not getting penalized because they notified the employee. Then there is no benching. But benching is where somebody is like just putting them on the bench, no project, putting them on active payroll, but not really paying them. So that is a problem. So normally, again, if benching happens, DOL can get involved, USCIS can get involved. If they get involved, other law enforcement agencies such as ICE, HSI, Homeland Security Investigations, Department of Justice, they all could get involved. So the bottom line is just talk to the employer right away, and if not, if a company is benching you, try to change your employer, because you need to mitigate your damages. That being said, there are enough protections in place where employer can reach out to DOL or USCIS, inform them, because DOL will typically get involved. They will assist whenever there is kind of benching and whenever people are not paid like they're required to. So use that recourse uh, if there is benching. And that being said, employers, because they have a problem, so we always tell employers, always be cautious, no benching. You should terminate the employees, give the employees. So basically, the employees, once they're terminated, they have to be offered the airfare back to the home country, and then settle all the pay issues. And then the employee gets the 60-day grace period, because employees will have 60 days in general to transfer their employment. If not, benching is always problematic. It is problematic for the H-1B program, problematic for the employee because employee is not getting paid, and for the employer because down the line they might even be debarred from the H-1B program.
Okay. So remember, friends, that benching is completely illegal, and you have your right to fight for it. Thank you, Chand, for taking all of our questions today and for joining us here for this amazing and insightful session here with all of us here on Immigration Talk Show. So thank you once again, Chand. It's always a pleasure to have you.
Thank you, Nipasa.
So I hope that we'll see you again in the coming weeks. And friends out there, do contact Attorney Chand if you need a one-on-one consultation, and the link is displayed here on the screen below. So have a great day, Chand, and thank you once again.
Thank you.
Also, to viewers out there, if you did not subscribe to our channel yet, please subscribe now. Our handle is at Immigration Talk Show. And you can also WhatsApp me or email me if you have any questions. So my email address is nipa@staffingme.com, and my phone number, where I also have a WhatsApp, is 408-335-6444. You can even call me on this number, or email. WhatsApp will be best. Pretty much, I'm active there. So send me your questions, and thank you so much, each one of you, for joining us here. And keep watching Immigration Talk Show because there's so much more lined up all about U.S. immigration. Bye for now.